State of Ohio versus Alyssa M. Smith. This is case number 25-CR-0136. Present representing the State of Ohio is Prosecuting Attorney Ray Grogan and Assistant Prosecuting Attorney Mark Weaver. Attorney David Johnson is here representing Ms. Smith, and Ms. Smith is present in the courtroom at counsel table. This case is back before the court for a sentencing dispositional hearing. You guys may be seated. Dispositional hearing. Ms. Smith pled guilty to count 2, endangering children, a felony of the 3rd degree. That plea entered on August 19, 2025. All other charges were dismissed pursuant to that plea agreement. This matter was referred to our adult probation department for a pre-sentence investigation. That pre-sentence investigation has now been returned. Has the State of Ohio had an opportunity to read that PSI?
It has, Judge.
And Mr. Johnson, have you?
I have, Your Honor.
Does the state have any modifications, changes requested, or anything regarding the contents of the PSI?
None from the state, Judge.
Mr. Johnson?
No, Your Honor.
With that said, the court has likewise reviewed it, finds it to be appropriately done, and the court will adopt it in its present form. This case is a Marcy's Law case. What is the state's compliance with victim notification and or presence?
Thank you, Judge. It's an odd case with respect to Marcy's Law in that the 2 most obvious victims, representatives, would be the parents of the deceased child, baby Royal, both of whom are on full notice about this through their respective proceedings. Our victim's advocate has been in touch with another family member of the child, an aunt, who is present, was advised of all the hearing dates, and is here today and is ready to speak to Your Honor. We believe we've met all of our obligations under Marcy's Law, Judge.
The court believes that the obligations have been met, and noticed what Mr. Weaver said is that this is a unique case in which the parents are also victims in the case as well as defendants. With that said, is there any reason why a sentence should not be imposed or this hearing should not proceed, Ms. Smith?
No.
All right. With that said, does the state have anything to present regarding sentence?
Yeah, Judge, the state would like to call the lead investigator of the case, Lieutenant Dylan Reese from the Marion Police. With your permission, we'll have him take the stand, and I'm going to have him help the court understand some of the facts of this case.
That'll be fine.
Lieutenant Reese.
Have you raised your right hand? You swear to tell the truth,
You
the
can
whole truth,
freely
nothing
move
but the truth,
about.
so help you God?
I do.
Please proceed.
Judge, just for the record, sorry, witness sworn. Are you ready to go, Judge?
Yep.
Just for the record, the state has prepared a PowerPoint presentation of images and 911 calls, that sort of thing. Defense counsel has a copy in his binder, and I also alerted him to this prior to this hearing. And with the judge, I'd like to present one to you as well. May I approach?
Yes.
This is the digital thumb drive we talked about.
Thank you.
The same thing that's in the. So I thought what I would do, Judge, is use the PowerPoint to guide the witness through what we're going to talk about. And so our witness is Lieutenant. So we'll start with the question. Would tell us your name, please, for the record.
Yeah, Dylan Reese.
What's your job?
I work for the Marion Police Department. I'm a lieutenant over the Detective Bureau.
And what relationship to this case did you have?
So I did not respond initially to the case. As part of my roles in the Detective Bureau, I performed follow-up investigation on this case after initial responding officers submitted their case.
In very brief fashion, identify the parties and what happened that day, who's who, perhaps the dog involved.
Sure.
This is not a full-blown jury trial where we have to go through every detail, but just so the record establishes who's who, where they were, and the date. Could you start with that, please?
Yeah, so several officers were dispatched and responded to an address on Miami Street here in Marion. Blake Bates called 911, advised his child, Royal Bates, had been attacked by a dog. Royal's mother is the defendant here, Alyssa Smith.
And as part of your investigation, did you find out whether there were dogs at that property?
Yeah, so there was a total of 5 dogs at the house at the time. The dog in question in this case was named Kilo.
What's the variety of dog or the mix, if you know?
I believe it was a pit mix, brindle colored.
And I'm gonna put on the screen something the state has marked as State's Exhibit 1. Is this image familiar to you?
Yeah, that was a photograph taken by an initial responding officer.
And as part of your investigation, you've reviewed all these images that I'm presenting?
Correct.
And is the dog that you see on the screen the dog in question here?
It is.
And based on your investigation, what did this dog do on that day?
So there were some conflicting stories on the mechanism, but essentially that dog pictured up there on the screen attacked 6-month-old Royal Bates, causing significant injuries about his head that ultimately resulted in his death.
As part of your investigation, did you review what I'm calling State's Exhibit 2, which is marked as a 911 call some year earlier to a different address, specifically April 8th, 2023? Are you familiar with that call?
I am.
Could you describe briefly what that is before we play it?
Yeah, essentially, the dispatch center received a 911 call from an upset mother. She advised a dog had tried to attack her child, causing some superficial injuries. The 911 call is rather long, but that's kind of the gist of it.
Okay. So have you had a chance to listen to the call to confirm that it's authentic?
Yes, sir.
All right, Judge, with your permission, I'm going to play that call, and then we'll discuss it. You bet.
Yes, I have a neighbor who lives behind me, and they keep letting their Pitbull out, and one of them just attacked my son. I was shutting them about it.
Hey, where are you at?
A 367 South Main in the back. I have 3 kids who were on our property. The dog came over and almost bit my son. He doesn't know how to model these. This is not the first time.
Okay. I just want to confirm with you here. It's 367 South Main Street here in Marion.
Apartment C in the alley, in the back.
Apartment C.
Yes, in the back. I'll be back there.
Alright, and what's going on?
The dog pretty much attacked my son. And I don't know if they just let the dog freely.
Now
Pitbull.
you mean pretty much attacked your son. Did he attack
Yes. He has got scratch marks on him. He's
you? Okay,
not
what did
sick.
you do?
The dog went to go bite my son. He was nearly at my son. He has a scratch mark from the dog's paw. The owner come out and yelled because they just let him out. This is not the first time. This is the second or the third time. You can ask my landlord. My landlord even called. Well, on our property, my kids were riding the scooters. I have 3 little kids. They were going to... my son is in tears.
I gotcha.
Because they need to let their dogs on the leash if they're going to let them out.
Okay. So they let the dogs out, and then the dog came after your son. He didn't bite him, but he scratched him.
He was going to attack my son.
Yep, I got
So
that.
I'm
I
letting
got
him
that.
out.
That he
I don't know if
attacked
it
your son.
happened. I have, like I said, I have 3 kids, and I'm shook up.
I got
3
you.
kids. And all I seen, I was getting my 3-year-old, because I have a 3, a 6, and a 7-year-old. I looked in that dog. If that owner did not come out, he would have ate my son up.
All right,
And I wouldn't know what to do.
Alright, do you want a squad to come check out your son?
Yes. I don't know. He's all shook in that.
Oh, it's up to you.
I want to spend with this dog.
I understand, but do you want a squad to come check your son out?
Josh, do you want the squad? Are you okay? I think he'll be okay.
Alright.
He's more shook than that.
Alright, if he needs a squad, you should let me know at any point. Are the dogs back in the house now?
The dog is back in the house. It's a big ass pit bull. I don't wonder if they have license for it. Probably not. This isn't the first time that my landlord called on them before because the dog almost attacked my landlord when he was fixing up these houses.
Okay, I got you. Are they in the same house as you, or do you know who they are, like what their names are or anything?
I don't know these people. I don't talk to any of them. I said my kids were riding their scooters. We just got white top put down and they were just minding their business, riding their scooters, and here's the big pit bull. And if the owner did not come out, my son would have got ate up. 3 kids out there with me. It's very unsafe.
Alright, what is your name?
Okay, Lieutenant, is that a relevant portion of the 911 call that talked about this dog Kilo?
Yeah, it's relevant. It's most of the call, in fact.
And is that part of your investigation to review things like this?
Yes.
And as part of your investigation, did you determine that whether the dog warden went out to look into this situation about the Pitbull mix, Royal coming out and going after small children? Was that part of your investigation to review what the dog warden did?
Yes, Deputy Scott Mills responded to the scene and handled that investigation.
And are you familiar with the body cam footage that the mother of these 3 children was recorded on, describing what happened that day?
I am.
Have you reviewed that footage?
I have.
Judge State's Exhibit 3 is a short portion of the body cam footage that shows the interaction with this mother we just heard in the 911 call. Permission to play it, Judge?
Yes. Fine, Jerry.
Okay, I'll play the whole thing. It's kind of long, but see my son sitting right there.
You let him out the door to go to the bathroom, and the dog was dark.
You can see him letting him out the door if you look real closely. And you have to look real close in the back.
The dog growls and goes to find his leg.
If he
Did
didn't
he
have
actually get bit or no?
he did not get bit, but he did have a scratch on the back of here.
Right.
If he didn't have his jacket hanging the way he did, he would have got bit.
Right.
This isn't the first time this has happened. He's been looking for his dog. He's been oh no, Christian. No.
That's a gun.
That's just me that one on my kid. He's just playing with the rocks. I didn't want to play with the rocks. It's about to come. I gotta walk away to go get my other son. And if you watch in the back, you can see him let his dog out. You gotta watch real carefully. You want me to zoom it in?
Yeah, there's the dog right there.
The owner comes. They just let their pit bulls run loosely.
Right.
And my landlord has called about last summer
Okay.
about a different incident, and you can ask him. I don't know exactly what happened, but the dog actually came in the house and he called the police.
Okay.
That was not the same dog. I've had a dog come around the corner to try to attack me. I didn't call the police because I'm like, oh, it's no big deal, whatever.
Right.
But when you're talking about my kids are sitting here on our property, and these dogs are not being locked up or on a leash, there's a problem and they're aggressive.
Are you guys getting ready to leave?
We were going to
Okay.
anyway.
That's fine. You guys can go ahead and go. I'll come back and talk to him. I have a dog.
Based on your investigation, Lieutenant, was that an accurate depiction of the body cam footage for this relevant portion?
Yes.
As part of your investigation, did you review the body cam footage wherein the dog warden interacted with the defendant, in this case, Alyssa Smith, and her co-defendant, Blake Bates? Did you review that as part of your investigation?
I did.
We have State's Exhibit 4 on the screen, which is a screenshot from the body cam. Based on that screenshot, does that appear to be the video in question, the relevant portion?
Yes, sir.
And this is that same day?
Yeah, it's just immediately after that segment of video we just watched.
To your understanding, based on your investigation, what is the dog warden doing in this video before we watch the portion of it?
So he's speaking with Mr. Bates and Ms. Smith about the incident where this dog allegedly went after the neighbor kid. He's determined that they don't have the dog registered. He's advising them that what happened isn't okay. He's advising them that he will be issuing a summons for failure to confine, and he's going to be giving them warnings for other issues such as the failure to register offense.
Judge, permission to play State's 4?
Yes.
Thank you.
After him, I have to cite you for failure to confine the dog. Okay. I will give you a break on the failure to register. I'm not going to cite you guys for that. I'm not going to hit you with 3 tickets right off the bat. You know. And I don't want to cause any issues with you guys. But yeah, he did grab the kid. I got it on video. He scratched him with his tooth. Yeah, it could have been worse with the kid. I think it was the kid's pants and stuff. Somebody grabbed the pants, but we got to make sure we keep an eye on him from getting out. So
That's
right.
totally
Yeah, we was already
understandable.
talking about it already.
right.
Yeah, but he's
Is
usually
he usually like? Is
He's
it
just
iffy
kinda-
about people or
No, he's
something?
kind of got a little different because now he had them puppies and all, and
Oh,
that's
so
why he's
there's-
not getting kicked.
Is the puppy still here?
Uh-huh.
Okay, how old are the puppies?
They're only 4 weeks.
Okay, so you still got 4, you still
Yeah,
got 4
he-
weeks, yeah.
yeah.
Yeah, you still got 4
So
weeks with
that's
them.
why we
Yeah, we
usually don't
just
let him
moved
out,
here.
let him out the leash.
So yeah, he's gonna be a little protective with the, I mean, yeah, granted, the kids over there, but still, like,
Still,
Yeah,
yeah.
he shouldn't have did that.
yeah, he should have done it, yeah, so I'm glad you got this up here, a lot of people
Yeah.
don't
I
think
usually-
about
yeah,
that.
See,
that's
that's
why I
what we
do it,
usually
keep
do.
it right here,
We
so
usually
it's-
have him on the leash, or we usually take him on the leash, take him right to the car to go bye-bye or
Just
something,
kinda,
and
you
it
know,
was,
that's
he
right
just
there.
slipped out of the house today, and.
Right, well, that's why I said, I get accidents happen, but when it comes to,
The kid.
I understand it wasn't like a full-blown injury, but he
But
still
still.
caused something,
Right.
there has to be a citation with
Yeah.
you, so. Give me a minute, I'll do that, and then just make sure you get registered, I will check, so,
Okay, that's
so,
Is this an accurate depiction of the warning that the dog warden gave the defendant about the dangerousness of this dog around children?
Yes.
And as part of your investigation, and we already have states one up there, did the dog warden go out to then flash forward now to the next year when the attack on the baby royal happens? Did the dog warden go out to then retrieve the dog in the yard where this was?
Yeah, the dog warden went to the hospital, talked with Ms. Smith and Mr. Bates, and then following that conversation, he went to Miami Street and collected the dog.
As part of your investigation, did you uncover body cam footage of the capture of the dog?
I did.
We have State's Exhibit 5 on the screen, which is a screen grab from the grabbing of the dog by the dog warden. Based on your knowledge of this case, does that appear to be an accurate depiction from the body cam video?
It does.
Permission to play State's 5, Judge?
Yes.
Kilo. You go in this garage. Come here. Kilo, come here. Come here. Kilo, come here. Come here. Kilo. Kilo.
Based on your investigation, is that an accurate depiction of the capture of the dog?
Yes.
Did your investigation uncover whether that dog had the blood of the baby on it when it was captured?
The first picture you took there, you can see that you put up at the beginning of the PowerPoint. There's in the picture you can see the baby's blood on the chest area of the dog.
Judge, I'm going to move to the portion we talked about in chambers with defense counsel.
Be fine.
Detective, as part of your investigation, did you uncover body cam footage of the child being taken from the house into the medic squad as it was being treated by emergency responders?
I did. It's body camera footage belonging to Officer Caleb Rector.
Judge, we've handed that up to the bench in digital form, should Your Honor want to review it as part of the record. It's identified as State's Exhibit 6. Because of the sensitive nature of those images and how upsetting it may be to victims, the state is not going to present it on the screen. So we'd ask you, Judge, to take that for the purposes you decide it should be, that's State 6, Judge. It's a screen grab of the beginning of the transport of the child from the front porch of the house to the medic. Did you, as part of your investigation, Lieutenant, did you also review photos taken of the hospital after the baby died?
I did.
And did you review what we're calling State 7, which is the clothing the baby was wearing that the emergency medical people had to cut off the baby in order to treat it? Did you review that?
I did.
And how best, without putting it on the screen and creating more trouble for anybody who's already mourning this child, how would you best describe what was, I think some people call it a onesie of the child? How would you best describe that in the image that is marked as State 7?
It's a light-colored onesie with tags that says 3 to 6 months, indicating size. It's been cut off of what would be the side, like around the baby's ribs. It's soaked in blood, in particular around what would be the neck area of the onesie. I would describe it as completely saturated with blood.
And then States Exhibit 8, similarly, did you review a photo that showed the injuries to the child's skull was taken at the hospital that day?
I did.
Still, Judge, we're not going to present this on the screen, but it's on the bench, and defense counsel has an image of it as well. Would you describe for the record, Lieutenant, what injuries you saw in the close-up image of, at that point, the deceased baby's skull?
The photograph was taken from an angle above the child, as if you were standing next to a bed, with its feet furthest away from you and head closest to you is the angle the photo is taken. It depicts an injury near the top of the baby's skull. In the photograph, you can see a very severe laceration. There's very obvious skull fragments indicating to me that the skull was broken. There's, for lack of a better word, a gaping wound into the head cavity of the baby.
Knowing that you're not a medical professional, but that you have eyes, would you describe the injury as minor, moderate, severe?
I would use the word horrific.
Judge, I don't have any other exhibits, but I do have a few more questions, and then we'll wrap this up. And
That'd be
allow
fine.
defense counsel to inquire. As part of your investigation of this matter, did you look into the defendant and her background with respect to factors that the judge might want to consider consistent with revised code 292912E, where the judge can consider any other relevant factor in making a sentence?
I did.
And what did you learn, if anything, about the condition of this baby Royal when born to the defendant with respect to whether there were any drugs of abuse in the baby's system?
Yes, so during my investigation, I obtained medical records for the day Roy was treated at Marion General Hospital. Included in these medical records from the hospital, as is typical, is kind of patient's treatment history. In this case, it talks about prior immunizations, things like that of the child. Of note, it talks about the birth of the child, and then it's noted that there was, in fact, fetal drug exposure, noted on October 24th of 23. It also notes neonatal abstinence syndrome, which, as you've already mentioned, I'm not a medical professional, but from the research I've done, that is essentially, in common terms, withdrawal from drugs.
The baby?
Correct.
As part of your investigation, do you routinely monitor jail calls of defendants?
Yes,
Did you monitor the jail calls of the co-defendants in this case?
I did.
Were there instances where this defendant, Alyssa Smith, was talking with her co-defendant, Blake Bates, on the jail calls?
Numerous.
And was there ever a time when they would speak in code?
Yeah,
What sort of
frequently.
code was used?
So, Miss co-defendant was being held on other charges outside of this case as well, and as a result of those charges, there was a protection order in place between the two, so it would have been unlawful for them to be communicating. So Ms. Smith would speak with Mr. Bates over jail calls using other people's phones and phone numbers, and when I say they speak in code, she would act as if she wasn't herself, and would speak as if she was a friend of hers in the third person oftentimes, and things like that.
Were you able to figure out the code though?
Yeah.
Wasn't hard?
No.
And have you observed all of the footage of the defendant, both the day of the attack, and then have you observed her in other settings as well, since you've been investigating this case? One of the factors the judge will have to consider is whether or not there's been genuine remorse. Have you seen anything in this case that would indicate to you as part of your investigation that this defendant has shown genuine remorse?
Prior to today and all of the evidence and personal interactions that I've had with the defendant, I haven't seen her so much as cry prior to today. In fact, I listened to a jail call between the defendant and Mr. Bates. So during the investigation, I made contact with the defendant at her home on Miami Street and asked her to sign a medical records release form so that I could get a copy of these medical records. In this phone call, she's referencing that interview that I conducted with her to Mr. Bates, advising her at that point she knew that her arrest was likely imminent. So as a result, she broke her sobriety, decided to party, drink, engage in illicit drug use, because she knew she'd be going back to jail, essentially.
Part of what the judge has to consider is whether or not she's suitable for jail, prison, or perhaps even going back to a home environment. Is there another child in the home based on your investigation?
Yeah, Miss Smith has a daughter named Heaven.
And again, because it's relevant to the court's decision, have you uncovered anything that would suggest a problem with the home environment that she might return to? Should the judge return her to that home environment?
Yeah, so she has, since this case, had a couple different boyfriends that I've been able to discern. Most recently, a gentleman by the name of Philip Simpson, who I'm aware of professionally. Excuse me.
How would you be aware of him? Is this somebody who has convictions?
Yeah, as a search of the clerk of court's website, both for common police court and municipal court, I'm aware of 2 prior felony convictions and 16 prior misdemeanor convictions.
Judge, defense counsel can inquire. I have a short argument after this witness steps down.
I have a couple questions.
Yeah.
You say this Simpson is somebody she's now affiliating with?
He's in the courtroom today, Your Honor.
Okay. Where would he be?
Back row on the left.
Okay. And when were you monitoring, what time frame, the telephone calls at the jail?
Essentially throughout my investigation.
Okay. So there's been numerous.
In excess of 100, Your Honor.
All right. That's all I have. Mr. Johnson, do you have any questions for the officer? All right. Thank you for your time. You're free to step down. Do you have any further witnesses?
No other witnesses. Short argument either now or at the conclusion of the state can wrap up its portion now, Judge.
I'll do it at the conclusion if you don't mind.
Yeah.
No further evidence or anything? Do you want to do the victims?
Judge, it's completely your call.
I prefer to do that, and then I'll let you summarize it.
Thank you, Judge.
I'll let you guys handle.
Yeah.
I see the victims
the
advocate
first-
too.
Well, the state has identified Aubrey Smith, the aunt of the deceased baby Royal, and so our victims advocate is here today. So if you would step forward, Ms. Smith.
Thank you for being here, Ms. Smith. Just state your name, then you're free to say what you think's important.
Hello, my name is Aubrey Smith. I'm Royal's aunt. I know this may come as a surprise to some that I'm up here today, especially because I'm Alyssa's sister. But I wanted to make sure someone was able to represent my sweet little boy and make sure that he gets the justice he deserves. On April 28th, 2024, my entire world was flipped upside down. I got a call from my dad, and he asked if I was sitting down and if I was alone. I was a little confused, and I told him yes, I was sitting and I'm not alone. He then broke the news to me that Royal had been attacked by Kilo, and that they were on the way to the hospital, but he was not sure how bad it was. I knew immediately I had to go over there to see my baby. I hung up with my dad, and then less than 5 minutes later, He called me back and told me that Royal did not make it. I completely lost it. We all ran out to our cars and got over to the hospital as fast as we could. I got dropped off by my sister Autumn and immediately ran through the doors to try to find him. I was distraught and having trouble breathing because I was crying so hard trying to find my little boy. When I heard the words "he didn't make it, sis" come out of my father's mouth, a piece of me broke and left. That day will forever be engraved in my brain, and I will never be able to recover from the pain and the hurt I felt that day. When I got to the hospital and I saw my sister just sitting there like nothing had happened, I was immediately angry. When I walked in that room and she was sitting on her phone like her son did not just pass away, I was still not 100% sure what had happened up to this point, but I knew that the baby that I looked at as my son had passed away from a 100% avoidable incident. When Alyssa realized I was in the room and saw me crying, she started crying also. To me, it felt like she was only crying because she knew I was. When we were finally able to go back and see Royal to say our final goodbyes, it completely shattered me. I had to see my baby boy lying on a table with a tube down his throat, lifeless. When I previously, the day before, saw him perfectly happy and smiling at my softball games. Seeing him like that made me realize everything had become real, and it made me realize that the baby I looked at, like my son, was really actually gone. When we were in the hospital, Alyssa just kept talking about how she wanted to go get high instead of the fact that her son had just died. I've never been an addict or even tried any drugs, so I don't know how addicts' minds works. But I cannot wrap my head around the fact that she wanted to go get high more than she wanted to go see her son again. When we left the hospital, she was more worried about being on her phone than anything else. I still to this day do not understand how she was concerned with being on her phone the whole time while we were in the hospital and after we left, more than she was concerned about the fact that her son had passed away. When we went over to tell Heaven, my niece, Alyssa's daughter, that her brother had passed away, Alyssa's exact words were, "Bubby passed away. He's in a better place now. He doesn't have to be a vegetable." How can someone refer to their own son who had just passed away as a vegetable? I understand shock is a thing, but that is never a way an innocent baby should be referred to. Alyssa was posting about having another baby just 2 days after Royal passed away. How can someone have their child die and then post on Facebook 2 short days later about having another baby? Someone who is truly mourning the loss of their child does not post about having another baby. A child is not replaceable like that. A child is not an object that can just be replaced because one was lost. I've had multiple people approach me and tell me that they saw Alyssa driving around town and walking around in stores, laughing and appearing like nothing was wrong on multiple different occasions the week that he passed away. I understand that life cannot just stop and come to a standstill when things like this happen, but acting like this does not show that someone is even remotely mourning or concerned with the loss of their son. Seeing the way Alyssa acted after her son passed away absolutely disgusted me and made me see her in a new light. I do love my sister and I do have love for her, but not the way that she's went about life and the way that she has done things. Now, I am in no way saying that Alyssa or Blake did this on purpose or that they wanted it to happen, but they had more than enough warning signs and opportunities to get rid of Kilo and avoid the incident completely. They both knew that the dog was aggressive, or whatever you want to call him, and neither one of them took the responsibility of getting rid of him to protect the 2 innocent children that were in that home. Fortunately, Heaven did not get hurt in the situation, but Royal lost his life due to his own parents' negligence. Alyssa and Blake are both equally responsible in this situation. Alyssa lost her son that day, and I'm not saying that she's not completely mourning him, but I do think she is mourning him for the wrong reasons. She has everyone else fooled by what she posts on social media, but I have seen her actions and her true colors, and I know what she's truly doing. She has shown me time and time again she's not reliable and that she does not truly care about the safety of her children, and this is sadly a huge example of that. If she truly cared about the safety of her children, she would have gotten rid of Kilo the moment she knew that he had any aggressive behavior. Again, I'm not saying it was done on purpose, but it was 100% avoidable. I've stayed in touch with Alyssa throughout all of this, but solely so I can keep in touch with Heaven and make sure that she is safe. Alyssa has put Heaven in unsafe situations before, and luckily they have worked out in her favor, and this incident is no different. But unfortunately, it did not work out in poor little Royal's favor. Alyssa has continued to put Heaven in unsafe situations and do things that she knows she's not supposed to be doing. I personally think Alyssa thinks she can get away with everything, including this. Alyssa is now living with a convicted felon that has multiple felonies for violent offenses and allows my niece to be around him with no care in the world. Alyssa has put my little girl through hell and back, and I strongly believe that she will continue to do so until she finally gets in trouble for her actions. Your Honor, I do not think 90 days is enough time in jail for Alyssa. She needs to understand the consequences of her actions. I have no doubt she loves heaven, but I also do not think she is the best person for heaven to be around right now. I do not want my niece to grow up and be like Alyssa. I have no doubt she loved Alyssa or loved heaven and royal, but she's a very selfish person and always puts herself before others and does not care about anyone else as long as she gets what she wants. I think heaven needs some time away from her mother and needs to see that there are consequences for your actions. Your Honor, I think Alyssa deserves the entire 3 years in prison. My little baby deserves justice for his life that was lost. Thank you.
Ma'am, I appreciate you coming in and sharing that insight. It's helpful for the court to have that information and background, so I appreciate your time here.
Thank
You
you.
may step back. Does anybody else wish to make a statement?
State has not identified anybody else, Judge.
All right. Anything further from the state?
I have just some closing remarks that would point you to the appropriate statute. Shall we do that now, Judge?
That's fine.
Yeah. Judge, for the record, we point the court to Revised Code 292912, the seriousness and recidivism factors. Turning to large letter A, the two that are most applicable from the record that we've seen here is number one, the victim suffered serious physical harm. Lieutenant Reese's testimony plus the state's exhibit. The baby was mauled to death by this Pitbull mix. So that's present. That's a factor indicating a more serious effect. Number two, the offender's relationship with the victims facilitated the offense. That appears to be there. The mother obviously has an obligation to protect the child. We don't see any of the other factors, 3 through 6, being applicable. When we turn to 292912B, factors indicating the offense is less serious, Mr. Johnson can argue that the state doesn't see that any of those apply. Turning to 292912C, which is factors indicating a higher likelihood of recidivism, we would point the court to factors 3 and 4. Number 3, that's a history of substance abuse, tends to lead to recidivism. And 4, a lack of remorse, as described both by Lieutenant Reese in his testimony and by the aunt of the baby. Looking at 292912D, the state wants to be as fair as possible. Number 3 probably does apply for a lower likelihood of recidivism. The offense was committed under circumstances unlikely to recur. The state would like to think that this defendant will never own a pit bull and have a pit bull around a dog again, around a child again. So I'll let Your Honor balance that. But by way of full fairness, we want to direct your attention to D3, which may be a factor that shows a lower likelihood of recidivism. With respect to 292912E, which are some people in sentencing law call that the catch-all provision, any other relevant factors, the state has presented those relevant factors to you in the exhibits that we've handed up and put on the screen that shows the seriousness of this offense. Judge, you should know that defendant's counsel advocated very aggressively and professionally on behalf of his client. Mr. Johnson was in touch with the state, pushing very hard for his client's interests. And only through his diligent approach did we consider some form of a resolution to this matter short of a jury trial. Because as Your Honor knows, a jury trial is a never guaranteed result. We would have to get a unanimous verdict on every element of every count from the jurors. And of course, there'd be many years of appeals afterward. And so with that in mind, defense counsel and the state came up with an agreed recommendation, largely based, Judge, you were here for the change of plea, you conducted the change of plea, because we have 2 other pending matters against the co-defendant, Mr. Bates, one of which is testimony in the case about Baby Royal, and there were only 2 adults in the house that day who could be suitable to testify, and Ms. Smith could avail herself of her Fifth Amendment right and not testified and not cooperated with the state. And then Mr. Bates, as the court knows, faces a strangulation charge related to a domestic violence incident where Ms. Smith was the victim, and there would have been no way the state could have required her to participate in that prosecution. So largely because we needed the cooperation of Ms. Smith in these 2 other matters, state was willing to accede to the diligent advocacy by defense counsel and recommend a joint recommendation of 90 days in jail. After we were able to make that agreement that the defendant here in this case would plead guilty, Mr. Bates then changed his pleas on the other charges, and we'll proceed to sentencing at another time. We'll talk about that then. Judge, whatever you do, the state stands on its recommendation, but whenever this defendant is out again, we would encourage the court to add additional factors to whatever release supervision she has, including no dogs, including no felons, including something about substance abuse, and something about maybe regular visits by children's services, so that if she does have her daughter with her, that there's somebody with an independent perspective who can ensure that that daughter is in a safe environment. So with that, Judge, the state is done with its argument.
Thank you, Mr. Weaver. Mr. Johnson, you have anything you want me to know about your client?
Yes, Your Honor. So I guess just at the outset, there were questions and testimony provided about fetal drug exposure. I candidly don't see how that has any relevance here whatsoever. We're here involving a dog, unfortunately, killing a child. I'm not sure how any evidence or testimony about what may have happened during the pregnancy has any relevance to what we're going on here. So I'd ask the court to disregard that. As far as the actual case itself here, Mr. Weaver, I think correctly summarized for the court that my client, she is a victim in a felony domestic violence case. I know myself, we have very experienced counsel in the room, and yourself, Judge, when you were prosecuting, or excuse me, when you were in practice as defense counsel, we all know domestic violence situations, that is not the first and only time that it's ever happened. It's charged as a felony, which by definition means it was not the first time. And my client was willing to cooperate through that process. We met with the prosecutor's office. So it's not just cooperation in this case, but also in the other matter involving Mr. Bates. I think that was probably rather important for the state of Ohio. It forms the foundation, I believe, of the recommendation that we're joining with the court in proposing the 90 days with community control. And I'm also going to surmise that the state probably provided that evidence to defense counsel for those two matters, and was probably rather persuasive in Mr. Bates eventually deciding to enter a plea. So there actually was real value in doing those sessions with the state and cooperating with the state. Just candidly, it probably assisted in leading to convictions in both those matters. Now, along those same lines, Your Honor, about domestic violence and never being the first time, people that are the victim of domestic violence, they continue to experience that on an ongoing basis, even when someone's incarcerated. That kind of pressure from someone can absolutely lead to someone continuing to communicate, continuing to be fearful of that person. So I guess, Your Honor, what I'm suggesting here is that if this matter had went to trial, those instances of domestic violence would more than likely have become relevant at trial as a necessary background. I believe Mr. Weaver and Mr. Grogan would agree with me that if we went to trial, there were evidentiary problems for both sides. There were going to be evidentiary problems proving one of the more severe offenses that had been dismissed from the state's perspective. In all candor, from the defense's perspective, there was evidence showing that there was, at least a negligence, even not maybe a recklessness, that led to the death of Royal. So I think we all appreciated that, and trying to come up with a resolution that seemed fair given what we had here, and also recognition that while Ms. Smith certainly played a role here, I think we can all acknowledge that Mr. Bates was sort of the person leading the charge. He had owned this animal beforehand. His own family members had told him that this animal is a problem, that the animal is aggressive, and it wasn't necessarily Ms. Smith's. She had no legal authority to tell him to get rid of the animal. So I think we all have a recognition that he was really the primary problem going on in that house. Now, also as part of our agreement, Ms. Smith cooperated with a Children's Services investigation. Children's Services came out to the house because my client still has another child in the house that she cares for. I think the state, from their perspective, wanted to make sure there wasn't an ongoing issue going on in the house, and so we agreed to that. We were very open about it. Children's Services came to the house and found no issues. That is also, I think, one of the reasons why the state was willing to move forward with this recommendation to the court. Now, Now, ultimately, Your Honor, and I think this goes towards the primary purposes of sentencing, and I would agree with the state that the primary purposes are to punish the offender and protect the public from future crime. In looking at the PSI, my client has some assorted traffic convictions, but her only criminal convictions are disorderly conduct minor misdemeanors. So she's never even had a criminal conviction for which she would be subject to any form of incarceration. The 90 days that we're proposing to the court, not only is it going to be life altering for her because she's never really experienced any form of lengthy incarceration, but I'd also suggest to the court, I cannot fathom for a parent a more severe punishment than recognizing that at least in part you played a role in the death of your own child. That's referenced in the PSI. To paraphrase it, she says explicitly in there that I'm pleading guilty of child endangerment because I played a role in the death of Royal. She's going to be in a prison of her own making for the rest of her life, having to live with and acknowledge the idea, and have her family members come in here and acknowledge the idea that she played a part in here. The court can fashion any kind of sentence that it wants. It can disregard the joint recommendation of the parties, but I guess I'm going to submit to the court that no matter what you do, there's no more severe punishment than having to live the rest of your days knowing you played a part in the death of your child. The 90 days, to be candid, seems more like it's a recommendation, but it's a visceral need to attach some level of punishment here. But I'm going to suggest to the court that it doesn't matter if you do 90 days, if you do 3 years or something in between, there is nothing that is going to be more of a punishment to Ms. Smith, than realizing that you played a part in your child passing away, and then having to explain that to your other child. It's not something I've ever experienced, not something I ever want to experience, but I can only imagine the pain involved in that and living with that for the rest of your days. So, Your Honor, I hope you take all of this information into account and fashion an appropriate sentence. And the parties themselves have, Mr. Weaver and I have spoken countless times about this, including when I think both of us were on vacation trying to figure things out. But we are familiar with the evidence. We're trying to come up with something that is reasonable here. And 90 days plus community control with the court not only supervise Ms. Smith, I think part of that would be not owning any kind of dogs. I think satisfies the need for punishment and also protecting the community. Thank you, Your Honor.
Thank you, Mr. Johnson. Ms. Smith?
Just real quick, Judge, the state agrees. The way that Mr. Johnson described the interactions and how the plea came to be, everything that Mr. Johnson said is correct.
Ms. Smith, you have an opportunity to make a statement here today. You're not required to, but if you wanted to, now would be the time.
All I'm going to say is when everything happened, I was very, very in shock. I didn't know how to act. I didn't know how to go about it, and I still had to be okay for my daughter that witnessed it. Here recently, with everything going on, I have started grieving. I have cried every night. Me and my daughter have cried. I've made sure she's got counseling. But as soon as everything happened, I made sure she was okay first. When everything happened too, I couldn't grieve. I was the only one working. I had to make sure we didn't lose the house, the car, anything. So I couldn't sit there and be depressed and cry and everything while Blake was doing all that. I couldn't, because if both of us broke, we wouldn't have anything, and then I would lose custody of my daughter again. All I'm saying is I miss my boy every day. I cry every day. I miss him every day. And this is my first time ever being in trouble, and it's really, really took a toll on me. That's all.
All right. Court has considered 2919B2. I've also considered the entire record, including the pre-sentence investigation report, victims' impact statements, the statement here today by Ms. Smith, Rule 11F statements regarding plea negotiations, the recommendations made by counsel, the plea agreement, statements of counsel here today, and the statement of Ms. Smith. Also consider the purpose and principles of sentencing as outlined in 292911A, and that states as in determining the appropriate sentence, I'm guided by the overriding purpose of felony sentencing, which are to protect the public from future crime by the offender and others, and to punish the offender using the minimum sanctions that the court determines accomplish those purposes without imposing an unnecessary burden on state or local or government resources. I'm required to consider the need for incapacitating the defendant, deterring the defendant and others from future crime, rehabilitating the defendant, and making restitution to the victim of the offense, the public, or both. I've also considered the seriousness and recidivism factors, all is contained in 292912. Considered the testimony here today from the officer, the PowerPoint presentation, the other information is provided by the state and the defense. This case is unfortunate in that there's loss of life, and that you, Ms. Smith, is or are a victim to this because you were the mother of the child. When the court looks at the sentencing criteria, there's only one conclusion that I can come to, and that's that you're not amenable to community control sanctions. This court is not going to follow the joint sentencing recommendation. While your lawyer did great work to get you that sentencing recommendation, I also would let you know I wasn't very happy about the plea. However, the things that were stated in this court today regarding complexities with criminal cases involving evidentiary issues, co-defendant charges, cooperation, and ultimately the state's prerogative in evaluating and assessing cases. Your defense lawyer's knowledge of the case, my knowledge of the case, comes largely at this point. While I was reluctant to accept a plea, I did accept that plea, which cuts you in a significant advantage and risk. So you need to remember that the court considers as part of this sentence the cases that were dismissed and the containment of damages that allowed. However, the court specifically finds that you have no remorse for this, or you at least shown no remorse. You also violated your bond while you were on bond. Then you turn around and back out. You were continuing your relationship with Mr. Bates through surreptitious means, which demonstrate that you're not following court orders. And you can look at me like you don't know what I'm talking about, but you must not have heard the officer testify about you using phones and fake names to continue your communication. While you might have cut a deal at the last moment to cooperate in the state's case, that was done, in my opinion, to save yourself and not for any other reason. The case did pen for quite some time. This case is quite old from the date of offense. I also find that you have a drug issue and or alcohol issue that you failed to acknowledge or take any ounce of responsibility for. It's also a case, while I agree with everybody's statements that there was no intention for this child to be harmed, let alone killed, it's also, putting it mildly, to say that you and Mr. Bates were extremely reckless in your conduct in owning this particular dog, having other dogs in the house. I watched a video where your dog attacks a child in the child's own yard because you turned the dog loose repeatedly with no concern of what the dog, havoc that dog wreaks on the public. And probably by the grace of God that dog did not attack that child worse than it did. The dog obviously has extreme violent tendencies where it mauled this child unprovoked for no reason. You've told numerous stories as to how it happened, but the main issue is you failed to remedy the situation by containing and controlling your dog. I've seen it over and over. You have this desire to have these dogs that have tendencies to be aggressive, and then once they demonstrate the aggressiveness, there's nothing done to contain the dog. You're clearly incapable of managing that particular dog. Very few people probably could, but yet you're letting it run through the neighborhood after you're told it almost attacked a child. Now that would be concerning to me. That would have been concerning enough for me to get rid of the dog when I can't control it and it goes into somebody else's yard. Fail to see the purpose of having a vicious dog, one that attacks for no purpose other than you think it's, I guess, cool to have that type of dog. I'm not sure what the point of having a dog that you never know is going to bite somebody. And that responsibility falls 100% on you and Mr. Bates electing to gamble. And when you gamble, with high-risk situations that you can't control, nor had much interest in controlling. The dog was aggressive to more than one person. Your own family members advised you to get rid of the dog, but again, none of that was listened to. The consequence of this case is grave. A child lost its life, and we can't look at the fact that, or ignore the fact that the ultimate consequence, because of your reckless conduct, resulted in an unnecessary death. I think it's very true to say that this is 100% avoidable, and there's no way that this court is going to ignore the severity of this case and your failure to understand why we're here. When your own family, and I'm not just talking about your sister, everybody else here recognizes your failure to recognize this, your conduct and your failure to understand the importance of pet ownership and, more importantly, having a child and your duty to protect the child. And this court can come to no conclusion other than that a prison sentence is warranted in this case. If I could give you more than 3 years, you'd get more than 3 years at this point, especially after the information that was presented here today. Court will impose a prison sentence of 36 months. You are now what's subject to being sent to prison. Once you complete your prison sentence, you're subject to what is known as post-release controls in this case. Post-release controls is discretionary or optional. Is that correct, Mr. Weaver? It's discretion on this particular charge still, right?
Yes, Judge.
You agree with that, Mr.?
I do.
You'll be discretionary or optional post-release controls for a period of up to 2 years on your release. That means you'll be subject to monitoring and supervision by the adult parole authority. You'll be given probationary type terms on that supervision. If you violate the terms of your post-release controls, you can be sentenced back to prison in increments of time that cannot exceed 1/2 of your original prison sentence. If while you're on post-release controls you were convicted of a new felony offense, you can receive an additional year in prison, or the number of months remaining on your post-release controls run consecutive to any time you get on the new felony. While you're in prison, you're not to ingest or be injected with any drugs of abuse. You must submit to random drug testing. While you're in prison, I don't make any determination whether you're eligible, but you may be eligible for up to 5 days of credit toward your sentence for each month that you productively participate in educational programming, vocational training, substance abuse treatment, or other productive programming. You will receive a fine of $1,000. Court costs will be assessed in this case, and there'll be a partial assessment of attorney fees of $500. I believe you have 13 days of jail credit. Does anybody dispute that? All right, you will be awarded 13 days of credit up to the date of sentencing, which is today. Ma'am, you've now been sentenced on this case. You will have a right to appeal your sentence within 30 days after the filing of the court's sentencing entry. If you cannot afford the cost of appeal, your appeal will be filed without payment. If you cannot afford a transcript, one will be provided you at no cost. If you cannot obtain counsel for appeal, counsel will be provided to you without cost. Am I missing anything?
Nothing from the state judge. I think you covered it.
All right. You will be remanded into custody. Anything further from the defense? All right. This matter is adjourned.
Thank you, Judge. Thank you, Your Honor. what?
You want me with you?
Yeah.
Okay.
So you're gonna see that first scene of it.
May be seated. Next matter before the court is 3 cases involving Blake Andrew Bates. Case number 1 is State of Ohio versus Blake Andrew Bates, case number 25 CR 0042. Second case is State of Ohio versus Blake Andrew Bates, case number 25 CR 0080. And the third case is State of Ohio versus Blake Andrew Bates, case number 25 CR 0138. Present representing the State of Ohio is the Prosecuting Attorney Ray Grogan and Assistant Prosecuting Attorneys Mark Weaver and Allison Kessler. Mr. Bates has 2 court-appointed lawyers. Mr. Jack Van Bibber is handling case number 25 CR 0080 and case number 25 CR 0042. Mr. Van Bibber is present, seated beside Mr. Bates. Don Wick, attorney, is representing Mr. Bates on case number 25 CR 038. Mr. Bates is present. Mr. Bates is in custody. This matter is back before the court after Mr. Bates was previously in court. Mr. Bates previously pled guilty in this court on each of those cases. The case was referred to our adult probation department for a pre-sentence investigation report. That report is back. We are now here for sentencing. Mr. Weaver, are you handling this primarily for the state?
I am, Judge.
All right. Have you had a chance to look over the pre-sentence investigation report?
The state has reviewed the PSI, has no quarrels with it, Judge.
All right. Mr. Van Bibber, have you looked over the pre-sentence investigation report?
I had an opportunity to review the pre-sentence investigation report, Your Honor. We have no objections to order or corrections at this time.
Mr. Wick, have you had an opportunity to review the pre-sentence investigation?
I have, Your Honor. Unfortunately, I think as it indicates in that report, that the interview itself was conducted prior to my client entering a plea in this case, and as a result, there was no discussion between the interviewer and my client on this case. I think there's a specific reference that the section that the defendant usually completes relative to their involvement or feelings about the case, my client was instructed to bring that to today's hearing, so I really can't comment too much on the PSI because it primarily involves my client's 2 other cases, which I was not counsel of, nor do I know really anything about the facts of those cases.
So you don't have any issues with any of the seriousness factors, recidivant factors outlined in here, or the general components of the PSI? I understand you to make a statement.
Again, the seriousness or citizen factors, I'm presuming, are to going to the 2 other cases where the PSI investigator says that we really didn't get involved in my case because it was still pending at that time. So I can't comment on those. When I read that, I presumed that those factors were relative to the 2 other cases, Your Honor.
Mr. Weaver, do you have any comment regarding that?
No, Judge, we think the PSI is a general snapshot of this defendant's propensity for committing future offenses, his family history, fiscal history, all the stuff we normally glean from pre-sentence investigation. So, Judge, we would suggest that it wouldn't affect the state's position, and unlikely to affect the judge's position.
Well, first of all, him not making a statement doesn't isn't held against him, which it would be in certain cases. That's not going to happen. Second, I think a vast majority of the pre-sentence investigation is the same. He's been incarcerated since that time, so like his educational history, his criminal history, his alcohol, drug history, his employment history, military history is all the same. We can agree on that, right?
I would agree on that, yes.
So as to the specific recidivism factors, I think a few of those are clearly overlapping as well, and seriousness factors. They wouldn't be the same for all, but for example, his prior record, whether he's been successful on community control sanctions before. And I'm capable of making any independent findings, which I do in any case. As you're aware, I often change findings within the pre-sentence investigation reports. But, I think some things are obvious too, whether it's physical harm caused in the case you're dealing with. I think that's inherent within that particular charge. There's certain other things, whether there's weapons involved. Most of them are going to be in his favor anyway. Like, for example, there was no weapon involved. He didn't hold a public office or trust. He didn't commit it as part of a organized criminal activity. It's not a sex offense. Whether somebody's served a prior prison term or not is objective finding. Whether he's on probation or not at the time, I think we can agree he was not at the time of that offense, because in time it was the first case he had. He was not in possession of a firearm. So with that said, are you satisfied that I'm going to make an independent determination on anything that would be not duplicative than already in the PSI as to his individual case?
That's correct, Ron. Just
Okay.
for the record,
Okay.
I wanted to place on the record the fact that the interview process and that portion of it,
I
as far
agree.
as defendant's explanation of events, taking responsibility for actions, remorsefulness, were not addressed as it pertains to my case, due to my case was still pending at the time of the interview.
Okay.
Thank you.
Anything you want to add to that before we proceed?
No, Judge, if there's a gap there, certainly when the bench asks the defendant if he wants to speak, he can certainly cover a lot of that if he decides to address the bench.
And I also would say I have some information that's related to this case from the sentencing of Ms. Smith, the co-defendant. They had a presentation that was video from the actual scene of the event. So I also got an opportunity, which I'll see it again today, of Mr. Bates's actions and inaction and responses when he was, he knew what was going on, which I think goes to him recognizing the seriousness of it and recidivism and remorse. Make sense? I have this information. You're going to watch it again, but it was applicable to him. Here's what I'm saying. If you want something else done before we have the sentencing hearing, now would be the time to say it.
The only question I have, Your Honor, is I've gained some insight due to certain recordings that I viewed of the sentencing of the co-defendant. I was not sure the witnesses, if any witnesses planned to be called. They were called in the other sentencing case. I wasn't sure whether the defense counsel had the opportunity to cross-examine the witness relative to certain statements that were made. That's what I wasn't sure of.
I believe there was an opportunity. I mean,
Okay.
I consider him as a witness, so whether he did or not, I don't personally
No, I
remember.
understand it. As long as the witnesses, any witnesses that are called
You'll be
on behalf of the
cross-examined,
state
yeah.
are subject to cross-examination. Fine, Your
Absolutely.
Honor. Thank you.
With that said, anything procedurally other?
Only to say, Judge, that when the judge's staff told us that there was a narrow window of time to complete this, that as you know, Judge, and as defense counsel knows, the rules of evidence don't apply in the sentencing hearing, so we are omitting witnesses and going to go with exhibits which have been provided to the defense.
All right. With that said, we have Marcy's Law compliance.
We do, Judge. Once again, it's a curious one. We have the aunt of the dead baby is going to speak as she did last time. And we have a discernible victim in the strangulation case, which is Alyssa Smith, who was the co-defendant in the child endangering case, who is present. And I believe is gonna speak, but we made sure she was notified and present.
And our office was made aware by somebody that she wanted to make a statement, so on abundance of caution, we had her brought here today.
Yeah, that's fine, Judge. We just, by way of notification, again, an odd set of facts. We thought an abundance of caution, certainly on the strangulation case, she's a discerning victim.
You have a comment, anybody?
I do, but it's not related to Marcy's law, Your Honor, so I don't know if you want me to address it now or during my arguments.
Is it procedural or is it
procedural.
mitigation?
I think it's procedural in that the state previously filed, Your Honor, a sentencing memorandum on or about, it looks like October 23rd of 2025. In reviewing that sentencing memorandum and in conversations with the state prior to going on to the record today, the state had made a recommendation as it relates to the sentence, specifically related to the strangulation and to the escape case, or cases, I should say, that they recommend, according to the sentencing memorandum again, was 18 months on the strangulation and 12 months on the escape. I think that the state is willing to amend orally here today that recommendation would be consistent with the joint recommendation that was contained within the entry of guilty plea filed on or about August 13th of 2025 in both 2025 CR 42 and 2025 CR 80, which would indicate an 8-month sentence in the strangulation case, running consecutive to the 12-month sentence in the escape case. So I just want to make that correction. I don't think I need to make an oral motion to strike if the state is willing to make that amendment on the record today in their recommendation. I do believe that is procedural, not mitigation. Thank you.
All right, thank you.
We are, Judge. I spoke to the defense counsel before the hearing. Scrivener's error, copy over. We orally want to put that into amend the sentencing memo. And in a moment, when I give the bench and defense counsel copies of what we're about to see, I've also written it in there to make it very clear. It will also be reflected when it appears on the screen. Thank you, Judge.
When I was reading the state sentencing memorandum, I had concerns that it might have had an error in it. I pulled the entry pleas of guilty to confirm the plea agreement, which was written in there, and it is correct that the state's rec was 8 months on 2025 CR 0080, consecutive to a 12-month in the other case. So 8 and 12 was the state's rec at the point, so I did catch that as well, and we'll hold the state, unless there's something I'm not aware of, to their plea negotiations for Mr. Bates' benefit, all right?
Thank you, Your Honor.
With that said, does the state wish to present anything?
Yes, Judge. May I approach with some copies of the handouts for you? Yes. All right, Judge, as I mentioned, for time purposes, because we know the time is limited, we will not be calling witnesses, but we will be sharing exhibits that were part of discovery, also shared with defense counsel. And I'm going to go through them each of the charges at a time. So, Judge, when I'm done, the state will have spoken on all 3 of these matters. I know we have 2 different defense counsels. I know you have different findings you have to make, but for purposes of brevity and efficiency, we're going to walk through all 3. The first one is the manslaughter conviction, Judge, which, as you know, is 290304. B, the court can choose between 9, 12, 18, 24, 30, and 36 months. The court knows that. The court may not know some of the evidence of the case, and as a result, I'm going to share some of that with you now. Much of this, Judge, you will recall from the previous presentation the state made in the co-defendant. And so although we don't have to say by judicial notice that we can say that several of these things you already know. There was an extremely vicious dog in the house where the defendant and the mother of the child were living. You saw some footage, Judge, of the capture of that dog and how aggressive and vicious this dog was. I'm not going to play it again because you saw it for one time. Again, trying to be efficient with our time, Judge. You had access to the photos of the horrific incidents of the child. I'm not going to put them up. The court had access to that. Just noting for the record, these were heinous, heinous injuries to this baby. One of the questions, of course, is whether the defendant knew that this dog had a history of being aggressive, because if he did, that makes the culpability much more serious. What you're seeing now is body cam footage from a jail interview with one of the investigators in this case with the defendant, who, just because of the angle of the sitting, we can see the left hand side of the defendant, but it's clearly the defendant. And the question that's being asked is whether or not there was a history of this dog. It was called Kilo, a Pitbull mix, whether there's a history of this dog being aggressive, and I'll make sure we can hear the volume, but this is what the defendant said.
Is that right? Okay. Was there a history of this dog being aggressive, or?
No, that's what we didn't understand. Everything was fine. We haven't had really problems with it.
Was the dog aggressive? No. Now, haven't had problems with it. We didn't understand. That's the story that the defendant gave to this investigator. Then the investigator asked a question about whether his grandmother had said, you know, did your grandmother tell you there was a problem with this dog and around children? The investigator had reason to believe that had happened, but the question was put directly to the defendant, and you'll see his answer.
How about is Audrey, that's your grandmother? Okay. I talked to her, and she said that prior to this incident, she's been begging you guys to get rid of the dog for a long time because it was aggressive, and
she just don't like the dog because it barks when people come at the door. And
she said that there had been several incidents prior to where it had tried to bite you, or I think the word she used was snipped at you.
Snipped at me?
Yeah.
I don't remember that.
You don't remember anything like that?
No.
Okay.
No. She's kind of over-dramatic with the dog. She's never like dog.
She's just not a dog person.
Knowing what we know, impression on behalf of this grandmother, this was, of course, false. The defendant knew very well that this pit bull called Kilo had not just been dangerous around the house, where the grandmother would have seemed dangerous around the house, but dangerous to other children in the neighborhood. Your Honor will recall we played a 911 tape in our last sentencing, where a mother in the neighborhood was reporting that this pit bull mix had come out and tried to attack her child, tried to bite the child, wound up injuring the child, not by a bite, but apparently part of the clothing protected the child. And you also remember, Judge, we played for you some body cam footage from the officer who responded, where the mother not only told about what happened to the child, but played video of it off her own phone. So again, for efficiency purposes, Judge, we will remind you that that was played before. What we didn't play before, well, I'm sorry, one more thing we did play before, Judge, is then, of course, the dog warden went out and talked to both defendants. You can see them in the screenshot from this image, and specifically said, your dog tried to attack a neighborhood child. You need to be cautious and careful with this dog around children. We played that clip for you, Judge. You remember that warning was made to both defendants on that day. This is the scene. I'm going to, before I go to a judge, there was the victim is nowhere in the scene. This is simply the scene afterwards. The victim is on his way to the hospital where he will be pronounced dead. But we're now going to hear that, in fact, that when this horrible thing happened, when this pit bull did attack and kill this infant, that the defendant is acknowledging at the moment that he knew he should have done something with this dog before this happened. Because remember, the story to law enforcement was we had no reason to believe this. Grandmother, she's overdramatic. There's absolutely no reason. He's warned by the dog warden, warned by the grandmother. Now that the horrible thing has happened, Judge, here's what he says.
The couch is fine. I went to pick him up.
Yeah.
It's my fault. It is not your fault.
He's on his knees crying, screaming out, "It's my fault." That's not the only thing, Judge.
Look, listen to me. Listen.
It's hard to understand. I played it several times. I believe the transcript is accurate. We should have gotten rid of him a long time ago. This, of course, suggests that he's acknowledging in an excited utterance, which, as you know, Judge, is more credible than other things said when you've had time to prepare what you're going to say to investigators. He's saying something that we should have gotten rid of a long time ago. Later at the hospital, after the child has been pronounced dead, investigators continue to talk to both defendants, and this was said to the investigator during that time in the hospital hallway.
I just need one of you guys to sign the dog over, and I'm taking it. You guys, I'm sure you don't want it back, ashes or anything like that.
That was my dog. I already know you're going to start hitting me now because this is my dog.
No, I just didn't want to sign that because it's...
So, to the mother of the child, yes, that was my dog, and you're going to start hating me now because it was my dog. Further acknowledgement of the two defendants with respect for responsibility for the dog. This defendant has a greater responsibility for this dog than the other defendant.
You did everything we...
No, bro. I've seen he's getting angry and being like that. I should have got rid of him earlier.
Same location, hospital hallway, signing some paperwork about the dog. I'd seen this is Kilo, was getting angry and mean like that. I is the past tense, so I had noticed that in the past, and I should have asked that, could have gotten rid of him earlier than that. Further evidence of the facts that the defendant was lying to investigators when he said he didn't know this dog was vicious. These excited utterances at the scene of the crime and later at the hospital that show that he in fact knew these dogs were, this dog was vicious. There were other dogs in the house that were downstairs. That's the overview, Judge, that we wanted you to see with respect to the dog portion of this case. In this case, it's the involuntary manslaughter. I think you were already familiar with a lot of it. This other evidence I'm about to play on this next charge, you may be less familiar with. This is the escape conviction, Judge. 29-21-34, as you know, it's an F3, and you can sentence 9, 12, 18, 24, 30, with 36 months. The defendant is in custody, and he's being arraigned or some sort of judicial proceeding for this matter over in the city building, which, as Your Honor knows, that there's a municipal court. I'm now putting on the screen the footage from the security cameras where he and a couple other prisoners are coming down the steps from municipal court. You're going to see them come down here in a moment in the top right. The first prisoner is the defendant, and he's ahead of the other defendants, and he's ahead of the deputy or the officer who's responsible for watching him and moving them back to where they were being held. You may be familiar with the layout, Judge. We're now moving down to the ground floor of the police station. There's a back door there. The first person out the back door, right there, is the defendant. That's the center one. And then on the right-hand side, Judge, is the shot of the parking lot just outside the back door of that building. I'm going to zoom in now in this next frame. Here goes the defendant. Off he goes. Running, escaping from custody. This is not a hearing about whether it's a smart thing to run in an orange jumpsuit while shackled at your waist off into the snowy parts of the city of Marion. But all of the officers that were put on immediate alert to go search for him, he's now out amongst the population of the city of Marion. Obviously desperate, obviously not making rational decisions, no idea what he's going to do to the people he may encounter. He didn't run into a government parking lot. He ran into a private home area, and one officer is going to find him. And so this next clip is from that officer's body cam, where you will see he is found between two private citizens' homes in the city of Marion.
I got him here. I got him.
Get on the ground.
Get on the ground! Get on your stomach. I got him on, Newman. I got him. Right there.
377-300.
Okay, so Judge, we saw the crime, the escape, and we saw the arrest from the crime. It's pretty obvious. Not much more to say about the escape, other than he's literally trying to escape responsibility for what happened in this case. It's going to be a theme, Judge. Moving to the third charge, which is the strangulation charge, Judge, and we've covered the manslaughter case, showed you some of the footage from that to give you a sense of the equities of that matter, showed you the escape case, pretty straightforward. Now the third one is the strangulation case, Judge. Under 2903.18, it's an F4 strangulation. There's different levels of strangulation. Your Honor probably knows Ohio was the last state to make strangulation a felony. Just a couple years ago, the General Assembly made it a felony offense. It could be an F2, it could be an F3, it could be an F4. This is an F4. This is the one the defense counsel and I discussed to make sure we have the accurate recommendation on there, but you can see all the possible sentencing ranges for you. This comes about from an encounter with this defendant and the mother of the baby who was killed, Alyssa Smith, at the home where that happened some months later. This is January 20th last year, and you'll see here on the screen, Judge, that the officer, after being told, and you're going to see a clip here in a moment from the body camera, being told by Ms. Smith that the defendant had strangled her, the officer asked her if she had any visible injuries. And then, Judge, if you look, you can see that there is a red mark here on the neck. Over the weekend, Judge, I was taking a CLE on strangulation, keeping up with my credits, and you probably know, Judge, because you've had this training at a judicial school, that the slightest amount of pressure on a human's neck, even one that wouldn't create a mark, is enough to meet the statute and certainly enough to cause damage with loss of breath. So you're now going to see body cam of the investigating officer talking to Ms. Smith about whether or not she was choked in an altercation between Blake Bates and Ms. Smith at the same house where the baby died. Here's the relevant portion, Judge.
Came out.
Okay.
So I left. I shouldn't have to leave my home, but I did to try to solve all this. I come home today, he wouldn't leave me alone, he kept going and going and going. He took my phone. I did go after him. I said, you know what, that's my phone, you know, I use it for work, like I need my phone. He swears up and down I was cheating on him, blah, blah, blah. He has insecurities, whatever, whatever. My grandma calls me, I answer it. I tell him, just, you know, just go. Before it gets worse, just freaking leave. So I was on the phone with my grandma. He ended up choking me up. He ended up throwing me on the freaking clothes in there. I don't know if there was anything, but he did. It was just for a quick second. Then he freaking slammed me on the ground and everything else. My grandma basically hung up with me and called you guys.
Okay. You said he was choking you up. Did it restrict your airway underneath?
Yes.
It did? Like it changed the pattern of your breathing?
Yes, and this isn't the first time. This is just the first time that I'm fed up with it and I'm done.
Okay. And then?
What she's describing, of course, meets the definition of strangulation, and she gave a little bit of context surrounding how that came to be. He's not arrested at this house, Judge, because just like he was trying to escape responsibility for the manslaughter case, just like he was trying to escape literally from the court building where the judicial proceedings were moving forward, he will now try to escape from this crime scene and runs into another neighborhood to a house that was tipped off the police he might be hiding at. That's this footage here. You will see he's hiding from the police in a rather cluttered garage of one of these houses nearby. Police once again are having to take great caution to confront a potentially desperate fugitive, and they have to have the canine dog go in to find him, and this will be the footage of the canine dog discovering him in hiding as he tried to escape responsibility from the felony strangulation he had just conducted.
Hey, come out now! Show me your hand! Show me your hand! Come out! Come out now!
Come out. Come out.
Keep your hands up or you will get paid. Do you understand?
Yes, sir.
Come out with your hands up. You are under arrest.
Okay. Yes, sir.
Do not reach for anything. Get up slowly. Get up slowly. Get up slowly.
I see.
Put your hands up. Hands on your head. Hands on your head. On your head. Step over towards me. On your head. Alright, hands behind your back. Come together. Yeah, like that.
So, I'm a warden, but I'm a fucking warden.
I'm going to let this play, Judge, because they're going to go out and ask him questions about the squad car. So give it a moment. We're going to walk him out.
You don't hear our commands?
Questions.
Huh? No, I'm just freaking out, dude. I'm just being...
What are you freaking out about?
And me and my girl got in a fucking fight.
You're the right human. I think you say can't
Hey.
I'd like to talk to her and have him represent through the questions. Can I afford to hire a lawyer, one to represent the questions you wish? Please stop answering our questions at any time. You understand, right? Yes, sir. Obviously, you're already saying why we're here.
Well, I just heard... I heard a warrant and I heard something else, so I asked.
What happened between you and your wife?
Found out... Sorry. Found out she cheated on me again, sent like $1,700 to a guy in jail, and...
Okay.
I took her phone, and when I took her phone, she got $40,000 and shit, and hit me with this, like, I don't know, it don't matter. got like shoved my way through where she come around me.
Shoved your way through and you
Yeah,
fell?
yeah. God have. Yeah, so. It ain't his fault. He didn't know I was back there.
Man, 4 people had your back on that one.
Just because I went out back.
When they get out to the car, Judge, you're gonna ask him if he has anything in the pockets that they need to know about. Anything alive.
I appreciate it. Thank you. Okay. Well, we got what we needed.
Alright. If you guys can just get names of witnesses.
This is the relevant part here.
Can I ask what was followed, like, or like what I'm being charged with? Or?
Honestly, I don't know. I'm not the investigating officer. I just came to help because I knew that you were here and you had a warrant. So, right here.
The warrant's like what, misdemeanor or something?
Like, do you have anything on you that you know about before you go reaching around?
I don't think so.
No type of drugs?
No, I have just a couple lighters.
No type of weapons?
No.
Okay. Nothing else gonna hurt you?
No weapons.
Positive I don't.
What's this?
I don't know. I just put these fucking on or take off running.
Blake, don't lie.
I'm just being honest. It's probably it's drugs, but I
What kind of drug would it be here? What kind of drug would it be?
Something like that.
Coke?
Yeah.
I should.
He lied, said he didn't have anything he needed to know about. He said this.
That's all I was came to, you know what I mean?
He also said no weapons. Let's check the right pocket.
Okay, when I asked if you had any weapons, buddy, you told me you had very...
I didn't even know they were in my. I'm so sorry. I didn't know they were in my backpack. I'm freaking out. Sorry, I'm not even thinking about it.
Continuing to lie to police, continuing to escape responsibility, trying to evade responsibility. Judge, you should also know that there's evidence that this defendant violated your protection order. You're familiar with the jail mail system where inmates can communicate with one another. One of your bond conditions was that this defendant does not communicate with the co-defendant in this case. And there were jail mail to Alyssa Smith under someone else's name.
Your Honor, I'm going to object at this time. I understand the court has the ability to consider whether bond violations are, in fact, it does have an impact on sentencing if he were to violate bond. I don't believe that there was a bond violation filed related to these messages. As such, if this is going to be subject to a consideration by the court, I think the defendant is subject, or would be, needs to be afforded the opportunity for there to be a cross-examination, for there to be a presentation of evidence directly related to this, and then the court to make a subsequent finding whether he did in fact violate his bond. There again, there is no bond violation filed, so I understand the effort of the prosecution here to spend 25 minutes on a joint recommendation at this point for at least 2 of the cases in an effort to paint Mr. Bates as a bad guy, but this I don't think is relevant for the court to consider at this point.
Well, I think, one, they can choose how they want to present evidence at a sentencing hearing. It's quite normal that we don't have testimony. It's quite normal somebody reads a letter, they tell their opinion. I think there's any other sentencing factor is relevant. I don't think he has to be found to have been a bond violator, to have been in violation of his bond. To his advantage, he didn't get probably charged or a BV bond violation because he was in jail. The point being, I mean, what bond violation is there going to be if he's in jail? What's the sanction? Don't do it anymore?
Well, Your Honor, I think that's exactly why the court, in bringing this up and the court considering it, it has nothing but a prejudicial effect without the appropriate administrative and procedural safeguards put in place to ensure that the defendant in this case actually did do these things. I understand it's alleged, and I think that's the problem, is that a sentencing factor and specifically the ability to go to prison. I understand there's a joint rec here, so I think it's a little bit of a nonsense point that we're even arguing about it right now. I would just ask that the objection be noted in that he did not violate his bond pursuant to any finding made by this court.
Mr. Weaver.
Yeah, first of all, the judge, the state will put on the record, as part of the universal agreement in this case, the state will not be prosecuting as a separate charge the bond violation. So any due process concerns have been resolved by the fact that I'm stating on the record we will not be bringing any additional charges related to this. Secondly, Judge, as Your Honor knows, that when it comes to your attention that your bond has been violated, it allows you, without any other due process, to make adjustments to bonds, which means there is a basis upon which a court can make some decisions based on a relevant fact. In this case, the statutory sentencing factors say that all other relevant information can be considered by the bench. I'm about to show you the video where he's going to acknowledge that he did this, violating your order. I'm simply starting with how it came to be, but in mere moments, Judge, in a very short clip, you're going to hear him acknowledging that he purposely and willfully violated your order. We think it's relevant.
Was this initially, was this joined for trial?
Was this joined for trial?
These were separated?
These were separated for trial.
Oh, yeah, there's cases, that's right, different trials.
I'm also got information that I can consider from Ms. Smith's hearing, which this was another issue there, but I'll go ahead, I'm going to overrule your objection. I'm going to have Mr. Weaver continue with his presentation, but I don't think he has to be found to be a formal bond violator, be in violation of bond. My point is when you're out on bond, we can make adjustments to his bond. When he's in jail and he's violating a no contact order, I suppose I could say he can't have access to the computer. I mean,
well, and that's actually part of the problem, Your Honor, is that I don't think the bond is actually put into effect until he signs and acknowledges the OR bond or the PR bond that's part of the bond itself when it's posted. If a bond isn't posted and you've not acknowledged an OR bond, you are not necessarily subject to those bond conditions because the bond is not in effect.
Okay, well, there's a no contact order.
But if it's subject to the bond itself, it's not actually in effect, and that's, I think, part of the problem here in determining whether he did, in fact, violate his bond as alleged by the state.
There's a protection order in effect, correct?
I beg your pardon?
There was a protection order, so he's violating the protection order.
Out of the municipal court, though, and that's part of the problem. We are considering things that are not subject to this proceeding because they haven't been properly brought to allege the defendant has done these things. I understand the court's position absolutely that he can present his case, and I respect that. And I'm not trying to get too heated here, Judge. But this, I assume, is relating to the two cases which we have a joint rec for. So I'm also not sure what the dog and pony show here we're doing to talk about a joint rec. I just don't get what I don't understand.
There's not a joint rec involving Mr. Wick's case.
There's not, but
and it's all being sentenced at one time, and out of efficiency, we're doing it all at once. So I got your note. Do you have any more comment on it?
No, Judge, thank you.
Thank you. Go ahead.
Again, I'm going to try to be brief, Judge. This is the jail mail from Zachary Schaffner to Alyssa Smith. That in, of course, you see references to Blakey, which is, there was some testimony at the previous sentencing hearing about code being used between this defendant and that defendant. But lest we have to guess whether or not this defendant did this, or lest we have to guess whether he knew that he was under this protection order, investigators came to the holding facility, asked him about it, and this is an exchange.
How it is.
It is what it is. I ain't gonna lie about that.
So, you're confirming these are messages between you and Alyssa Smith, correct?
Yes.
Okay. So you were using Zachary Schaffner's email to contact Alyssa, correct? Okay. And then you used Matthew Henderson used him to create a three-way call with you and Alyssa, correct?
That's with Jessica.
With who?
Jessica.
What do you mean?
I've been talking to the girl named Jessica with Matt.
Okay. Have you used him to speak with Alyssa over the phone?
That was a long time ago.
A long time ago? Not last night or early this morning? You sure?
Yeah, I did.
You did? So this is you and Alyssa? Okay. Okay. So, obviously you know there's a protection order between the two of you, right? Looks like you were served back in January. on the protection order, okay? You do have one prior protection order violation, which makes this one a felony, okay? So obviously you're gonna be charged for that.
We'll come to discussion of what degree it might be. As you know, Judge, I said the state will not be bringing it. The investigator did point to the fact there was a previous charge of violating a protection order that was filed in Marion Municipal Court. The facts here, Judge, are once again, he's trying to evade responsibility. He's trying to escape responsibility for all of these different charges, both the horrible death of his baby, the escape, and the strangulation. So he's admitted to them. That's why we're here today. The sentencing factors, as the state has put forward in its sentencing memo, pretty obvious here. You've gone through them. You know them. You do them in all the sentencing. Let's see if we can apply them as best as possible. We think they lean towards consecutive sentences in every situation, particularly when you look at 29-29-12, the seriousness and recidivism factors. The baby in this case certainly suffered serious physical harm. The baby was mauled to death by a Pitbull. That's something the judge has to take into consideration. It was the offender's relationship, this defendant's relationship as the father of this baby, the person, perhaps the most important person in the world to protect this baby from danger, actually brought this dog, which we already showed you he knew this dog was dangerous, brought and kept the dog and other Pitbull type dogs in the house as well. That facilitated the offense. That's obvious. And then when you look at those that might make this less serious for purposes of sentencing and recidivism, it appears that these things do not apply. Defense counsel can argue their case. We think they do not apply. Higher likelihood of recidivism. There are some key things here. He's previously had some minor level criminal offenses as outlined in the PSI. We don't think he's shown remorse, Judge. I'll let you make the ultimate decision on whether he's shown genuine remorse. Certainly as being talked to by the investigator about what happened, lying that he had no knowledge that this dog was aggressive, tends to make one think that there's no remorse here. And we will allow you to apply the lower likelihood of recidivism. We don't think they are applicable. Once again, defense counsel can make that argument. So we talked about the other relevant factors under 29-29-12, and we presented them. This is the recommendation, and this does reflect the accurate count after we made the scrivener's error update that we discussed at the beginning of the hearing. The state recommends 36 months on the manslaughter, 8 months on the F4 strangulation, and then 12 months on the F3 escape to be run consecutively with one another. Judge, we think that is the only way to get justice in this case. If and when this defendant gets out, we also think to the extent that the judge has the ability to, this defendant should not be able to own dogs of any sort ever again. The notion that he would continue to keep dogs in the house after what happened and then deny responsibility is one that, whatever your sentence is, Judge, we think you should include that as part of the order. That's the conclusion of the state's case. Thank you, Judge.
All right, Mr. Van Bibber, anything you want me to know regarding the two relevant cases that you're handling?
Well, Your Honor, I'm going to briefly just touch on the last portion. I understand that the dog bite case is separate, from the strangulation and the escape case. But there was a condition that was requested that he never be allowed to own dogs again. I don't think that's within the purview of this court to be able to do that, and given that we're just sentencing together, I have no objection as it relates to any disposition of the two cases that I'm addressing. That being said, Your Honor, I would also again note that there was a joint recommendation in these matters in the, 7-ish years that I've practiced and the 10 years before that I've been a part of the legal field. I have never in my entire life seen and I will say it was a very nice presentation, and I do appreciate the walking through it, but the vast majority of this really tries to utilize the strangulation and the escape convictions, which he has taken. He pled to the indictment. He pled to the charges that were brought by the state. There was a joint recommendation for them, sure. And there was some knowledge charges, if I recall correctly, domestic violence that was taken off of that. But the escape was the escape. He pled directly to that. And there was a joint recommendation, again, as it relates to the disposition of the matter. But that's normal plea bargaining. Your Honor's been a part of prior to taking the bench and then, disposing of cases since you have, probably thousands of those. That's how we get cases resolved. And so because of that, I find it somewhat disingenuous to say that because he, when speaking to the police or when being investigated for other crimes, he may not have been forthcoming with the officers at that time. He was also doing that without the advice of counsel, without being placed under oath. So the Supreme Court has made time and time again statements regarding how we are to perceive individual statements, specifically when they are addressing a court or a tribunal, how they are when they are addressing the officers in the everyday field, or when they are put under oath and things like that. It is a different standard that we are to utilize. Sure, he should be forthcoming and honest, and the PSI notes that as it relates specifically to the two cases that I'm talking about here today. So I'm not going to belabor the point, Your Honor, other than to ask that the court hold the state and the defense to the joint recommendation that has been made. I do not think that the dog bite situation, I think that the timeline of events, which the court is familiar with, I think if we look at that, the state had full knowledge of all of these factors, all of these circumstances, when they offered the joint plea. And I think that the ability of the state and the defense to come together and make a joint recommendation to the court should be adopted as it relates to case number 2025 CR 42 and 2025 CR 80. I greatly appreciate the court's time, and I do believe my client does want to make a statement regarding this case, but I think we're going to do that together after Mr. Wick has an opportunity.
And we'll probably do that after the victim's statement. I
Yeah,
probably should have maybe done that
The
already.
victims do want to speak, and I want you to put that wherever you want to appropriate. If the state's done with its portion, and
Okay.
wherever you decide the victim should speak, that's fine.
I probably should have done it after you. I'm going to do it after Mr. Wick, and then Mr. Bates can, unless you want.
No, I prefer Mr. Bates to just have the opportunity to kind of close everything out
Okay.
if we could.
Mr. Wick, you have anything let me know about Mr. Bates?
Your Honor, I think first and foremost is the fact that my client lost his son. And I think that plays very much into what the state wants to talk about as far as statements made about this dog. I think that any parent, when faced with the situation that Mr. Bates faced that day, the loss of a son, he as a parent acknowledged, I'm a parent. I take responsibility for it. I don't think it's the responsibility to say that I had a vicious dog, but that I had the responsibility to protect my child. I think it's also critical in the court sentencing of my client that the facts of that day are very clear, and that is my client was with the mother of this child, and the child, he then left the child in the company and in the protection of mother to go downstairs. They had recently moved into this residence. He was downstairs cleaning out boxes. When he left, the child was with mother as a form of protection. My understanding is the mother has given 3 different versions of what took place during this actual confrontation between the child and the dog, whether mother was even present. This is not something that my client had any control over in the incident involved. I think the court needs to look at that and the fact that my client left the child in the company of the other parent in this case. We also have the situation in the sentencing memorandum where the state says that my client ignored explicit warnings. The only warning he was given at the time of this alleged incident with his prior neighbor was not to let the dog run. And I think that the facts, as the state is aware, my client said I was letting the dog out. There's a leash right by the door. The dog got out. The child was not attacked. The child had a scratch which mother presumed was the result of this dog. But that's the only contact between law enforcement or dog warden and my client. So I think it's a misstatement to say that he ignored explicit warnings. This dog was such that he had the dog. The statements that were made relative to aggressiveness were made at a time when his son was dying or potentially dead. I think also the state, in their sentencing memorandum, wants to make the allegation that the dog's name, Kilo, implies some sort of drug usage by my client. It's interesting, when I just Googled the name Kilo, it came up as an African name used to talk about first and chief. It also Google went on to say that Kilo is now a popular name for dogs, as it implies strong, dependable, protector, and legal. It also references Kilo Ren, which is a Star Wars character. So I think that that's an attempt by the state to muddy the waters that has no real effect on the sentencing of this case. I think the court also has to take into consideration that while my client was charged with manslaughter as a felony of the first degree, the state did not pursue that to trial. Now, I know the court can take into consideration charges that are reduced or dismissed. However, in this case, Your Honor, the state couldn't prove the F1 manslaughter charge. He pled to an F3 manslaughter, which talks about as a result of a misdemeanor child endangerment case. I think that's critical in this. This individual has no prior felony offenses. It doesn't take into account those dismissed charges. Now, my client at the change of plea hearing admitted his responsibility as an adult and as an owner of this dog and as a parent. However, I don't think the court can lose sight of the fact that my client lost a child, and I think that needs to be taken into consideration when the court looks at sentencing. I think specifically the punishment factors is that my client has in fact lost his son. My client has spent a considerable amount of time incarcerated. I think that will not demean the seriousness of this offense. Initially, Your Honor, if it weren't for these other two charges, that there was a joint recommendation that I was not part of, I'd be asking for community control in this case, Your Honor. And I think that the seriousness of this offense would not be demeaned by the fact that my client be given community control to ensure that similar ownership of animals is not taken into consideration. I would ask, though, now that the defendant has entered into a negotiated plea on his other pending charges, that this offense be run concurrent as to the other two charges, Your Honor. I think that my client serving the 20 months on these offenses, on these other offenses, is sufficient enough, given my client's involvement in this case, and specifically the acknowledgement of wrongdoing, the taking responsibility for it, and the fact that my client is a victim in and of himself, having lost a child, Your Honor. Thank you.
Thank you, Mr. Roy. I'd like to hear from Ms. Smith first, please.
Ms. Smith, if you want to be heard, this is your chance.
Sorry.
Just for the record, this is Alyssa Smith.
Yes, I'm Alyssa Smith. Me and Blake dated for about 2.5 years. This man has lost a best friend.
aunt of the victim of the case, and that'll be the final victim. I believe that's the final victim we're hearing from. Yeah.
You may come forward. If you could just give me your name again. I know just give me your name again.
Hello, my name is Aubrey Smith. I am Royal's aunt, and I'm here today to make sure my sweet boy has representation and gets the justice that he deserves. On April 28th, 2024, Royal lost his life after just 6 months and 4 days of being here on Earth. He only got 6 short months, but in that little amount of time, he stole the hearts of so many. On April 28th, 2024, Royal was attacked by a dog in his own home under the supervision of his own parents. Everyone keeps saying it was a tragic accident, but it was far from that. Yes, it was an extremely tragic event, but it was not an accident. It was an incident. It cannot be considered an accident when Blake and Alyssa both knew how dangerous Kilo was, and yet still chose to keep him in the house and around the 2 innocent and defenseless children in the home. Blake and Alyssa both knew that Kilo was aggressive, or whatever term you want to use, but yet still chose to keep him in the home and around the children. They both had more than enough warnings to get rid of the dog, but yet still chose to keep him, and sadly, my sweet boy lost his life due to that. Royal tragically lost his life, and his big sister had to watch the incident take place because of Alyssa and Blake's negligence. Multiple people, including myself, Blake's grandmother, and Blake's mother, offered to help get rid of Kilo, but yet they still chose to keep him. We all told them that it was not safe to have Heaven and Royal around such a dangerous dog, but yet they chose not to listen, and now my sweet boy is gone forever because they chose to keep a dog over protecting the children in the home. I'm not saying this was done on purpose or that either one of them wanted it to happen, but they also did not do anything to avoid it either. If they truly cared about Royal and Heaven in any way, they would have done anything to ensure their safety, but clearly they did not care enough. Blake may have shown a little more emotion and remorse than Alyssa, but I still do not think he was truly mourning the loss of his son. After Royal passed away, Blake continued to be reckless and continue on with his life as if nothing had ever happened. Him and Alyssa went about their lives as if their son had not just died. I'm not saying that he didn't mourn his son, but I do feel that he has shown no remorse for the incident that took place. Royal could still be here today, and would have just turned 2 years old this past Friday, if his parents would have been responsible and loved him enough to get rid of the dangerous dog in their home. Blake and Alyssa are both equally responsible for the death of their son, and I believe they should both serve the maximum amount of time possible in prison. Royal deserves justice for his life that was lost. They both lost their son that day, but it was due to their own negligence and decisions that they made. Blake knew how dangerous and vicious Kilo was, but still kept him in the house with 2 small, defenseless children with no care in the world. A parent who truly cares about their child would do anything and everything in their power to make sure that their child is safe, and Blake couldn't even get rid of a dog to protect his own child. The loss of Royal has absolutely destroyed me, and it's something I'll have to live with for the rest of my life. I will forever try to think of ways I could have saved him or gotten him out of the situation sooner. Having to grieve the loss of a baby who felt like my son is something I never could have imagined myself having to do. That's not even the hardest part of it all, though. Having to watch Heaven grieve the loss of her little brother is even harder. Heaven had to watch her little brother, an only sibling, get mauled by a dog and die right in front of her. That is something she will never be able to recover from or get the pictures out of her head. My little girl will never be the same ever again. She will forever have to live with the guilt that she could not save her brother, when in reality it was not her fault at all. It was Alyssa and Blake's. Due to Blake and Alyssa's negligence, Heaven will never be able to live a normal life again. She will forever be haunted by the fact that her brother is gone forever. I personally believe Blake thought he could get away with this and everything would be swept under the rug. The past and the ones that came after. Your Honor, I strongly feel he deserves the entire sentence in prison. Royal deserves justice for his life that was lost. This incident has impacted so many other lives and left so many people heartbroken. There are many people who love Royal so much and are absolutely shattered by the loss. Blake and Alyssa have caused so much hurt to people. The incident was completely avoidable, but they didn't care enough about Royal or Heaven to protect them. Thank you.
Thank you, Ms. Smith. I appreciate your time and taking the effort to write that. Anything further from the state?
Nothing from the state to submit for your decision, Judge.
Mr. Van Bibber?
Your Honor, I believe that Mr. Wick and myself would like our client to make a statement regarding both cases at this point in time. However, he's pretty distraught, as the court can see. He's emotional. He has written a statement if the court would allow me to read it.
Yeah, I'm just for procedural purposes, there's no reason a sentence should not be imposed or the hearing should not go forward, is that correct?
No, Your Honor.
And Mr. Bates, I'm going to say this just for the record as well. You have an opportunity to make a statement here today. You're not required to, but if you wanted to, you could. You can also have one of your lawyers make a statement, or you can make a statement, but we will accommodate whatever, so you have this opportunity.
Your Honor, he's elected for me to read the statement. He is emotional. So, on behalf of Mr. Bates, well, it was just another normal day, and I was doing stuff around the house, and I went down to the basement to look for some things that were still boxed up. We had just moved into the new house and had only been there a month, maybe a little longer. And I had just left the living room with my son and his mother and my stepdaughter all there together. I told his mother I was going down to the basement and that I would be back up when I found what I was looking for. I was down there for 15 minutes max, and all of a sudden there was screaming upstairs, and I ran up there as fast as I could and found his mom trying to tug him from the dog, so I grabbed the dog's mouth and pried it open. Then she takes the baby out front, and I lock the dog out back and call 911. I still don't know what really happened to cause this to happen. His mother has told 3 different stories as to what went down. Still, I blame myself for owning the dog, and I still take responsibility for this happening. I'm his father, and it's my job to keep something like this from happening. With that being said, his mother was there, and it all happened, and I was not, and that's where I messed up. It has haunted me every day since, and I will for the rest of my life. It eats at me, knowing that I'll never see my baby boy walk, talk, or grow up and experience anything life had to offer.
Thank you. Anything from you, Mr. Wick, further regarding anything?
No, Your Honor.
All right. All right, the court has considered 2919B2. I've considered the entire record in this case. I've considered the pre-sentence investigation report, the victim's statements made here today. I have considered Rule 11F statements. I've considered the plea negotiations in this matter. I've considered statements of counsel, the presentation of the state sentencing memorandum as amended. I've considered bond information. I've considered information that was provided in essentially the co-defendant's case, Ms. Smith's case. Had a little different information, but it was all involving this incident and certain recordings from the dog warden interview and body cam footage that's relevant to Mr. Bates. I've considered the purposes and principles of sentencing as outlined in 292911A. And in determining the appropriate sentence, I'm guided by the overriding purpose of felony sentencing, which are to protect the public from future crime by the offender and others, and to punish the offender using the minimum sanctions that the court determines accomplish those purposes without imposing a necessary burden on state or local government resources. I'm required to consider the need for capacitating the defendant, deterring the defendant and others from future crime, rehabilitating the defendant, making restitution to the victim of the offense, the public, or both. Consider the seriousness and recidivism factors under 292912. I want the record to be clear that this court has independently reviewed each case, independently reviewed the sentencing factors independently of each case, has independently reviewed the seriousness and recidivism factors in each case, independently made findings of those things, considered remorse independently in each case, considered things independently. I don't have any clearer I can be. I understand what Mr. Wick said at the beginning. However, the bulk of the pre-sentence investigations are relevant in all. I did not hold it against Mr. Blake or Mr. Bates in any fashion for not giving a statement at the PSI. He made a statement here today through his lawyer. I do have to follow the sentencing guidelines, and in giving this, I also have to recognize that there's a whole lot of people here who this case, in particular the dog case, had a lot of collateral damages. And there's no way the court can ignore the collateral damages that these people suffered. Aubrey Smith is only one. Everybody else here also suffered, and the court has to consider that permanent impact that it had on a lot of other people. I also must consider Ms. Smith, meaning Alyssa Smith's statement, her request for a lesser sentence for you regarding her strangulation case. That was factored in. The court also has to consider that I have less flexibility in sentencing on F3s. It goes from 9, 12, 18, and so forth. So it's sometimes harder to pick a sentence that may fully be perfect when you have skipping of 3-month increments and so forth. So the court factored that in. Bottom line is, I think the court is also entitled to consider things like the parties' continued communications with this case. Hard for me to understand that. I also have to, while you're in jail, and when people don't follow court rules, but when they also don't follow them while in jail, that's a problem. Court also had to consider Mr. Bates would have had this case, meaning the manslaughter case, pending out there, lingering out there, and then there's a strangulation case, and I have no idea what's going on with this escape, but it puts, the escape case puts officers in a bad situation. The thinking, the logic, the thought process that went into that shows no comprehension of the severity of your circumstances. You chose to worsen your circumstances by doing that with virtually no possibility of a real escape. Caused a lot of hassle for the police, the transport officer. The public gets scared. They don't know what you're out on, and they see a person in orange or hear it. It causes panic. These things are all separate offenses. I also note that I do think you have a substance abuse issue. You deny that in the pre-sentence investigation report. That's another factor. I think one or more of these crimes at least had some connection to drugs. You have meth in your pocket. Court has to consider as well the charges that were ultimately plea bargained. I only give so much weight to that in this case. I think Mr. Wick is probably correct in pointing out that it might have been a tough case to prove on an F1, but it could have been, and if that would have happened, the starting point would have been a 3-year sentence. So the court considers that. Based upon the video I watched, I do think you have some level of remorse for the loss of your child. I'm not sure it's probably to the level it should be, but I do think you have some level of remorse. I think your statement today at least leans that way as well. I think your grief was somewhat genuine, obviously, at the point of the thing, but I just don't think you modified your behavior. So this court is required to follow the sentencing guidelines, take all these factors. It's a complex case. But the court finds that at this time that you're not amenable to community control sanctions and that a prison sentences are warranted on these cases. As to case number 24, CR 42, which is the strangulation case, court's going to impose a sentence of 8 months.
Did you mean, I'm sorry, Your Honor, did you mean 25 CR?
Yeah, I'm sorry. Well, yeah. Is it a 20? If it's a 25 case, yeah, 25 CR. Sorry about that. CR 42, a sentence of 8 months. On case number 25, CR 80, the escape charge, court imposes an 18-month prison sentence. On case number 25, CR 180, involuntary manslaughter, court imposes a 36-month prison sentence.
That's 138. I think you said 180.
All my notes are wrong. 138.
I'm
sorry about the errors in the sentencing or the case numbers. In the manslaughter case, involuntary manslaughter is a 36-month prison sentence. Those sentences will be served consecutively for a total prison sentence of 62 months. In finding that consecutive sentences are necessary. The court finds that consecutive sentences are necessary to protect the public from future crime by this offender and to punish the offender. Court finds that consecutive sentences are not disproportionate to the seriousness of the offender's conduct and the danger this offender poses to the public. Court also finds that the defendant did commit the escape offense while the offender was not only awaiting trial on his strangulation case, was in custody and actually fled from a court proceeding. The court also finds that you do have a criminal history of criminal conduct that demonstrates that consecutive sentences are necessary to protect the public from future crime from future crime. I also feel that the harm caused to the infant was extreme, and that no single prison term is very unusual, great, so extreme and so great and unusual that no single prison term for these offenses would reflect the gravity and the severity and the trauma of that event. Court, in the strangulation case, there'll be no fine. Court costs will be imposed. Court-appointed lawyer fees will be waived. In the escape case, court costs will be assessed, attorney fees waived, there'll be no fine. In the involuntary manslaughter case, court costs will be assessed, be a $1,000 fine, and $500 of the court-appointed attorney fees will be assessed. Appears that there's different days of credit. Looks like he has a total max as 263 days. If these sentences are ran consecutively, it would be my intent to impose the 263 days on the case in which he served the longest amount of time. And Ms. Tanner, make sure I'm not wrong on the case number 25 CR 042.
That's correct, Your Honor.
So he'd receive 263 days of jail credit on that case. And then he would receive 0 days on the remaining case. Am I wrong on that? Because otherwise there's double counting, Mr. Weaver.
I think that's right, Judge.
Yeah. So he's getting the maximum days that he served in jail applied to the first case, which is 04.
Judge, I'm not great at math.
If there's more, then it rolls over.
Yes.
Beyond his sentence.
I would agree with that.
Yeah, because I think it's 240 days on his case. Right.
240 on
his sentence.
25 CR 42, and then the remaining 23 will roll over to 25 CR 80. Is that the court?
That's correct.
Okay, thank you.
So,
I just want to make sure.
obviously that rolls to the next case in order, which would be 25 CR 80. So just apply those extra days in the sentencing entry, and then he'd have those extra days on that case and 0 days of credit on 25 CR 138. Mr. Bates, you are subject, is this a mandatory or discretionary on that manslaughter? DRC?
I believe it's mandatory.
Okay. I think it's mandatory as well. Does anybody disagree with that?
No, Your Honor.
All right. In your case involving the manslaughter charge, you are subject to a mandatory term of post-release controls of 1 to 3 years. That means upon the completion of that prison sentence, you will be subject to mandatory post-release controls, which means you will be supervised by the adult parole authority. If you violate the terms and conditions of your post-release controls, you can be returned to prison in increments of time, and those increments of time could add up to 1/2 of your original sentence, but they could not go above that. If you committed a new felony offense while you were on post-release controls, you can receive an additional year, or the number of months remaining on post-release controls run consecutive to or in addition to any time you got on the new offense. On the felony, other felony 3 and the felony 4, post-release controls are optional, discretionary for up to 2 years. Do you understand that? Do the lawyers want me to reread the PRC stuff, because it's identical to what I just said, other than it's discretionary and optional?
We waive.
All right, you understand that, Mr. Bates? I'm not going to reread that repetitive. Mr. Bates, while you're incarcerated, you may not ingest or be injected with any drug of abuse, and you must submit to random drug testing. While you're in prison, you may be eligible to earn between 1 and 5 days of credit towards certain sentences on your case or charges for each month that you productively participate in educational programming, vocational training, substance abuse treatment, or other programming. You've now been sentenced, Mr. Bates. You will have a right to appeal your sentence within 30 days after the filing of this court's judgment entry. If you cannot afford the cost of appeal, your appeal will be filed without payment. If you cannot afford a transcript, one will be provided you at no cost. If you cannot obtain counsel for appeal, counsel will be provided without cost. Am I missing anything, Mr.
Yeah, Judge, we did some prosecution math.
Okay.
Prosecution table on the
Good.
credit. We want whatever the defendant is entitled to. We think it's 281.
We would, defense would agree.
Okay.
I apologize.
Oh, no problem.
I would just note that 263 it appears, Your Honor, was as of 10/9/25 when we were previously scheduled.
Okay.
The hearing was then moved, so that with the additional time between the two, I think that's where the additional days came in. The defense would stipulate to 281 days.
So 281 days will be applied to the first 8-month sentence, and the balance rolls over, and the third case gets 0 days.
Yes, sir.
Mr. Wick.
Your Honor, the only thing that I would ask, given the extended incarceration of my client, that the imposition of fines and costs be stayed pending his release.
We're not going to stay.
Thank you.
All right. All right.
Thank you, Judge.
All right, that'll conclude the matter.
Thanks, Judge.
Sorry, I just knew what I was looking at.
appreciate it.
Pardon?
41 days.
Put it on the, yeah, that's fine.
On the escape.
Three hearings upstairs.
I believe it.
Yeah, you just email it to me or text me.
Yeah.
We'll knock that out.
Okay.
Those two get along better now than they ever have.
Good, gentlemen.
See ya. Thank you.
Did you have additional questions? I'm more than happy to answer.
I do.
Yes, sir. The only thing is I think the judge here is going to be holding an arraignment session. So that we can do it in the hallway.
The hallway is perfect. I just need a couple minutes. to
Yes,
change-
sir.
change
I'll
gears.
talk with the family while we do that. We'll go from there.
Do you have any questions for Don or I?
If you'd like to talk, the reporter person on the page is down in Cincinnati, she's not able to make it up.
Okay.
But if you have some comments about the something that might be helpful.
What do you think about it? I'll meet you in the hallway.
Think
about it, Jack. Yeah.
Do you want to get that set for me?
Yeah, get that set up for me. Hey, Brent, have you checked everybody in for arraignments?
Once I get them.
Thank you.
Yeah, no, I checked everybody in.
Oh my gosh. Sorry. Hey, bye.
Go back and put these on the files.
Let me get out of the way as fast as I can, bro. You're fine.
Don't go right on them. I know. I've got it. Unless it's yours.